practice.
And the question is, with respect to self-executing, just so I understand what you mean, what would a self-executing subpoena look like versus what we have here?
Yeah, so the difference between a self-executing subpoena and this subpoena. So a self-executing subpoena would impose some penalties or consequences from the moment of the issuance of the subpoena itself. So
if the person didn't respond.
Correct.
So so you could go to court, the AG would go to court and not ask for litigation over whether or not they had to respond, but just ask for a penalty to be imposed.
That's
a self-executing
That would be a self-executing subpoena.
So what do we have here? Not that.
Not that, because the AG has to make a request to the state court, and any production of documents, any legal obligation to produce documents, is entirely contingent on a future state
Well, I got to say, though, look, putting my lawyer's hat on, if I were a New Jersey trial court, I would still be making the argument that New Jersey courts are not bound by the Third Circuit's decision that this is self-executing. But I want to put that aside for a second and ask you, you said in your opening that if we adopted this pre-enforcement theory, we would be throwing the door open wide and that there would be all manner of challenges in federal court to subpoenas issued in New Jersey. Can you give me some examples of this Pandora's box?
Yeah, it's a difficult question to answer, I think, Justice Barrett, in part because this would represent a pretty dramatic sea change in historical practice. Petitioner in the United States haven't identified a single case that adopts this credible threat of enforcement theory for subpoenas in particular. So this would be a pretty extraordinary change. And I think the risk would be that federal courts would potentially be inundated by these subpoena cases. So,
and what kinds of cases? And are we only talking about First Amendment cases? Are we talking about other constitutional challenges?
I don't see a way to limit the United States' proposed rule just to First Amendment challenges. I think it would encompass Fourth Amendment challenges, to Justice Sotomayor's examples earlier, due process challenges, extraterritoriality challenges. Just to put this in perspective, the single state agency that is before this court today from a single state has issued more than 500 subpoenas this year alone to all kinds of businesses, to home contractors, to car dealerships, who we have reason to believe could be violating the law, and so we want more information. Google, in its public disclosures, a single company, said in 2024 it alone received 50,000 subpoenas across the entire United States. You're talking about a huge volume. You're talking about many different kinds of potential federal constitutional claims. And I think all of that is why the United States is asking for a bespoke exception for its subpoenas in particular.
I'm sorry, finish your answer.
Yeah, the United States is asking for a bespoke exception for its subpoenas in particular. And I'll also say, as a final note on this point, that petitioner themselves on page 22 of their reply brief says, don't reach the questions about the credible threat of enforcement outside the First Amendment. You can resolve this case on chill. We agree ultimately chill is the right framework for resolving this case. And I would think if this court wants to take up the credible threat of enforcement theory, it would want briefing, for example, on some of the history and tradition arguments that we had raised in our red brief and that the reply just doesn't address. And so I think that this court can appropriately leave those questions for another day and decide this case on the basis of chill.
Counsel, you referred to the fact that you've addressed these subpoenas to car dealerships and things like your friends on the other side don't represent a car dealership. Do you think there is a credible chilling effect from the state seeking full names, phone numbers, addresses, present or last known place of employment of every one of their donors who gave through any means other than the one specific website? In other words, do you think they have a credible chill concern?
I don't think that, and I think that's best illustrated by the allegations that are in their complaint as well as in the supporting declarations in support of their motion for a preliminary injunction. So if you look at their complaint allegations, all of the harms they identified are tethered to a future downstream state court order requiring disclosure, but they're not tethered to the subpoena itself. As I noted in my opening, I think the closest they get in their complaint is at Petition Appendix 137, this is paragraph 125, where they say the subpoena, quote, may cause people who associate with First Choice to reasonably fear that they themselves will face retaliation or public exposure. That may cause language has never been sufficient for Article 3. The rest of the allegations in their complaint, take a look, for example, at paragraph 73 or paragraph 76 on Petition Appendix 130. Those allegations are focused on the harms from the disclosure of documents that identify First Choice's benefit donors, but all of those harms, again, are contingent on a future downstream
So you don't
state
think